Good morning.
Morning.
Good morning.
How is everybody?
Great.
Good. So when it comes to the laws, there are a lot of questions from a lot of different perspectives. We hope that to be able to answer at least some of these questions today. So first question, who am I and who's on stage today? So my name is Jacob Lowry. I'm the Executive Director of the Turquoise Museum and also the event organizer for Turquoise United. I will be moderating today's discussion. We've worked hard to try and include every perspective and question we can in that video. In the interest of time, we're not going to be taking questions from the floor. If you have any questions that we don't get answered, please feel free to find panelists after the session and ask them individually. Today we have some representatives from different departments of the federal government. Because they work for the government, they are constricted off of what they are allowed to talk about and discuss because of their department's specific purpose. So I'm going to let each of them introduce themselves and what the subjects are that are in their specific wheelhouse.
Good morning, everybody. Can you hear me okay?
Yes.
All right. Good morning. My name is Matt Werns. I am the Director of the Federal Trade Commission's Southwest region, which is located in Dallas and includes New Mexico, as well as several other states. The Federal Trade Commission is an independent federal agency that has two missions, one of which is antitrust and the other is consumer protection. And so when we look at a legal issue, whether it be in the context of Turquoise or other consumer issues, we are looking at from the consumer's perspective. That can include individual purchasers of goods and services, and also sometimes we have taken action to protect small businesses as well, and I can get into more detail about that later. I should note, kind of as a standard government disclaimer, that I'm here speaking and my views are my own and they don't represent that of the Federal Trade Commission or any individual commissioner. But I look forward to participating in this panel today.
I think that's as far as the cord goes. Is that working? Okay. There is more cord. All right. I'm Ken Van Way. I am a program analyst with the Indian Arts and Crafts Board. We're an agency within the United States Department of the Interior that's designated under the Indian Arts and Crafts Act to receive complaints about misrepresentation under the Indian Arts and Crafts Act, which is a truth in marketing law governing the sales of art and craft work in the United States as American Indian or Alaska Native made. I've worked at the board for about 25 years now, starting as a secretary and working my way up. Along the way, I got a master's degree in folklore, which is not necessarily the same as being an attorney or something, but a lot of what people know in the marketplace is folklore rather than what's necessarily in statute or regulation. So that's sort of where I fall in on this.
My name is Sean Hirons. I am a criminal investigator with the Department of Interior, U.S. Fish and Wildlife Service. And I work in a specialized unit, which is about 9 of us, and we do Indian Arts and Craft Act investigations. So we work hand in hand with the IACB. They refer complaints to us. We review those complaints and then decide whether we open an investigation or not. As it refers to Turquoise, I can't say we particularly do any action associated with that, even though quite often a lot of the jury or individuals we're looking at are using fake turquoise and not actual turquoise. But in general, we just do general investigations on IACA. Hopefully I can answer any questions if you have any today. I'm limited in my responses on certain matters, but look forward to it.
Yeah, I should probably clarify a little bit on that too. So I am not able to talk about any ongoing cases. We're gonna briefly touch on the fact that there are some regulations in play and a possible Senate amendment to the Indian Arts and Crafts Act. but both of those are outside of what I'm doing, so I'm not really able to speak to those directly.
Okay, so I have a question to start. Why is it that Fish and Wildlife is the investigative body, not FBI? How did that happen?
I don't know the full details about it, but the FBI is more than welcome to work these cases. Actually, any federal agencies is capable of working these investigations. It just came into a good fit since wildlife quite often is a part of a lot of Native American jewelry, and a lot of stuff is imported, particularly possible fraudulent jewelry that's going to be represented as such. So it was a good fit, and we're within the Department of Interior, like the Indian Arts and Crafts Board, so that works too. But any agency is more than welcome to work these cases. It's not strictly focused on just U.S. Fish and Wildlife Service.
All right, so as you can tell in the video, the questions today are about the laws that govern the sale, trade, and representation of the semi-precious gemstone known as turquoise. When purchasing diamonds, consumers expect laws to govern how dealers handle the sale. We all know that there are laws that are either about the gemstone turquoise or include the gemstone turquoise. So the first question is, what are they? What laws govern turquoise?
Sure. So I guess I can speak briefly from the Federal Trade Commission's perspective. One of the laws that we enforce, the principal one we enforce, is what's called the Federal Trade Commission Act, and it broadly prohibits unfair or deceptive acts in or affecting commerce. And that's not turquoise specific, but it would apply to the marketing of jewelry and turquoise. And in fact, the FTC has published what are called jewelry guides that are available on our website that kind of take this very broad statute, the FTC Act, in these very broad words, deceptive and unfair acts and practices, and filters that through the lens of what that might actually mean in terms of the marketing and, from the consumer's perspective, purchase of jewelry. Now, those aren't standalone regulation jewelry guides. They're meant to instead provide guidance to industry and to consumers on what might constitute a deceptive or unfair practice under the FTC Act. I will say there are other potential rules and laws that we enforce, and then I'll turn it over to my co-panelists up here that could apply. So, for example, if you're marketing over the internet or through mail or telephone, we have a regulation called the Mail, Internet, Telephone Merchandise Order Rule that broadly applies to shipping times and representations that you may make about when a consumer can expect to receive a good, and making sure that you're making good on that representation. And then additionally, to the extent that you're making any claims about where something is originating from, it may be subject to the Made in the USA rule, which we also enforce.
So there are a checkerboard of state and federal rules on this, and I think I mentioned I'm not an attorney, but I deal with the Indian Arts and Crafts Act, which deals with whether something was actually made by an Indian under the Arts and Crafts Act rather than what the materials are. And we do not limit materials under the act, but the New Mexico state law and the Arizona state law, I believe, both have some materials issues in them. So I recommend that you familiarize yourself not just with the Indian Arts and Crafts Act, but also with the relevant state laws. So within driving distance of here, Texas, New Mexico, Arizona, and Oklahoma all have their own laws. Some of those have some restrictions that are more restrictive than the federal act, and some of them have things that are a little bit less restrictive than the federal act. I do have some brochures for the Arizona and New Mexico laws up at my booth if people want to stop by afterwards too.
As for this question, we will document if actual turquoise is not being used and it's a fake turquoise or black turquoise. We will document in our reports, but we do not enforce laws associated with this. We strictly focus on the Indian Arts and Craft Act specifically. I mean, I've had a case, a closed case in the past where the person was claiming, I believe it was Lander blue turquoise. Most likely it was probably Chinese turquoise. Irrelevant to that, yeah, I document it, I'll put it in my report. It just shows probable cause associated with the person being deceptive, but outside of that, I do not enforce the laws associated with that.
All right, so let's start off with the easiest question to ask, but maybe not the easiest question to answer. How can someone buying the gemstone turquoise know what they're getting? How does the law protect a customer? I guess first would be, are there different laws for wholesale buyers versus retail buyers?
From the FTC's perspective, no. I mean, there's not different laws. When we've taken enforcement actions, when we put out industry guidance, it's frequently, we have gone upstream so that we're not just, taking action against a retail seller who may be relying on information that they got from a wholesale seller. Looking back at enforcement actions that we've taken over the years, they've frequently been against wholesale sellers. In terms of what the separate question of what a consumer can do to protect themselves, we have a fair amount of guidance online actually about how to protect yourself when buying jewelry, including Indian jewelry, or jewelry that's being marketed as a Indian style jewelry. And I can recap that briefly here. It'll probably be familiar to those of you already in the audience. But for example, do your research ahead of time, right? There's nothing worse that you can do than show up unprepared and hope to be able to find out a bunch of information on the ground in a whether it be a tourist environment or a specialized art market environment. Do your research ahead of time. Ask for documentation in connection with your purchase. And so if something is being represented as coming from a particular source or being of particular veracity as far as the quality of it, making sure that you have documentation in connection with your purchase that documents that, so that it doesn't turn into later a he said, she said over what was represented to you or what might have been listed in connection with the purchase of the transaction that you now are at a loss to go and recreate later. Common sense rules that any of us would use in any sort of important commercial transaction, not just specific to turquoise.
A lot of the Indian Arts and Crafts Board's guidelines have actually been done in cooperation with Federal Trade Commission going back decades. Yeah. So a lot of our tips are pretty much the same, but yes, get things in writing. I would say also everything we're doing are truth in marketing laws. So as a consumer, you should at the least familiarize yourself with the terms that people are going to be using, so that if you're being told something is a particular thing that has a meaning that everybody understands it to mean, or potentially has a meaning under law, that is what you're getting, and get your documentation to state that Southwestern jewelry, Native American style jewelry is not the same as Navajo jewelry, and that just because something, as you all know, has some turquoise on it does not necessarily make it a Navajo or a Zuni product, and that you as a consumer cannot make that assumption. For purposes of the federal law, it's misrepresenting it. For some of the state laws, there's a proactive requirement that things be labeled, and you should properly. So imitation Indian goods in some cases need to be marked as such. I believe South Dakota's law even specifies the size of the letters on the sign that you're supposed to have near those objects. So definitely learn the terminology, because the person that is going to be selling it to you is going to be intimately familiar with what language is and is not in violation of the law, and in many cases will skirt as close to that as possible and rely on your assumptions.
So when we say make sure you know the definitions, when we talk about gemstones, one of the things that people represent, there's a whole lot of different words of whether it is a natural diamond, a genuine ruby, a synthetic sapphire. All of those words are used in different ways. When we're talking about the gemstone turquoise, what words are defined by law and what do they mean? Does natural have a specific definition? Is there something that you could say it's natural treated, or is it natural only because of the definition? I know, Matt, you sent me a link to FTC guidelines that had a bunch of definitions in it. Do you remember what they said?
Here, I thought this was gonna be one someone else could take. So it's important I think it's important to distinguish between what the law says and the guidance that we've put out, which is essentially an interpretation of law, but were this to end up in federal court, wouldn't necessarily be the law as we could enforce it. It would be up to a judge, right? Federal laws tend to be quite broad and tend not to impose really specific restrictions on font size or terminology. And instead, there are very broad laws that are really focused on what is a consumer likely to take away from a communication, and are you making representations that a consumer is likely to misunderstand. And so some of the definitions that I think we may have been emailing about are definitions about, say, treatment of turquoise that and I have a list of them here somewhere in my notes, but that if you're representing something as being turquoise and not clarifying that it's been treated in certain ways, that you may be leading consumer down the wrong path as far as what they're likely to expect, what they're likely to take away from that interaction. When it comes to state laws, there may be much more prescriptive requirements of what you need to disclose, how you need to disclose it, what you might need to get in acknowledgments even from a consumer for.
Yeah, because the Indian Arts and Crafts Act doesn't deal with materials, we don't get too much into that. But the one exception would be the brochure that the Indian Arts and Crafts Board put together with the Turquoise Museum that does answer some of these questions about materials and treatments. I would recommend directing consumers to that and directing to consumers to our various other state brochures to give them a grounding in that. And we can also make those available to businesses to have in their stores if they want.
So one of the things when we talk about paperwork and documentation, one of the big buzzwords in our industry is the word provenance. So when we talk about provenance, people say, I want the receipt from the person you bought it from, and the person they bought it from, and the person they bought it from. A couple of months ago, I teased a piece of Lander Blue Turquoise that we just got in out of a collection and said this will be coming up for sale sometime soon. And a bunch of people asked me if there was provenance on it. And they wanted a receipt that tracked all the way back to the miners at Lander Blue. Well, I have receipts from the miners at Lander Blue that are for a couple of pounds of turquoise. So you go ahead and prove to me that that stone isn't in that couple of pounds of turquoise, and I'll try to prove it is. So does provenance actually protect anybody? Is there recourse if If I was to buy something from person A and sell it to person B using the receipt from person A, the person B, if they find out that that's not right, I gave them no documentation as far as what I was saying it was, and person A never had a contract with them. They had a contract with me. So is there actually legal recourse for provenance, or does each dealer need to represent in writing what they're selling with a backup of provenance, but not necessarily that being the only thing? Hopefully that's not too leading of a question.
Well, I guess, again, not an attorney, but I would recommend as common sense, what you can get in writing, get in writing. If somebody has something that's gonna go all the way back to that, then I would certainly think that would be good. But again, the Indian Arts and Crafts Act was not necessarily concerned about the turquoise, it's gonna be concerned about the object as a whole. So if somebody can track it back to the artist or to the whoever worked with them, to the sellers, whatever middlemen, everybody along the way, it's to their benefit to have something in writing from the person that they bought it from, just to give them some sort of grounding for what they're saying. But as far as materials, that's a little bit more in the weeds than I would get.
Yeah, and I think it's important to separate out from a legal perspective a couple of different concepts here. One is contract law, right, which is not something the FTC does not, nor does, to my knowledge, any governmental agency get in the business of litigating, enforcing private contracts between individuals. That doesn't mean that there couldn't be a violation of one of the laws we do enforce, but to the extent that there's an issue either in a retailer-consumer contract or a retailer-wholesaler or between two retailers, whatever it may be, to the extent that there is a violation of that contract, that is not something that the FTC, state AGs, et cetera, generally enforce. That is a dispute to be resolved between private parties. Where we get involved is what representations are being made to consumers, or in some cases, as I mentioned earlier, between wholesalers and retailers, and are those misrepresentations, are they deceptive? And I realize that, you know, legal terms of art like misrepresentations and deception can sound a little bit mysterious. I tend to think of deception as honesty being the best policy, right? And so what's the opposite of that? That's where we get involved. As it relates to something like provenance or certification, we tend to look at a couple of things. One is, you know, is the seller in this circumstance, do they have a reason to believe that what they're saying is in fact not true? Is it actually false? Then there might be a violation of the consumer protection laws, and that could be at a state level, it could be at a federal level. A second question is what's called substantiation, which is a really fancy term for what basis do you have for the claim that you're making. And that the basis that the law requires is sort of a sliding scale, and it depends on the seriousness of the claim that you're making. And I don't mean to diminish the seriousness of turquoise, but if you're claiming that you're selling a medicine that can cure cancer, you're going to need, like, you know, lab studies, double blind, all that type of stuff, probably FDA approval, things of that nature. If you are instead in a position where you are selling a good or service that, for example, does not touch on concerns of health or wellness or safety, and instead is about the provenance of or you know, that I should not use the word provenance, the history of a particular good that you're selling. The way we would look at it is, do you have a reasonable basis for the claim that you're making, that this is land or blue turquoise? And if you do, it's going to, we would probably make a judgment call that is adequate substantiation. Now, some of that, what is reasonable, may turn on questions like, well, what's reasonable within the industry? What's a standard industry practice? Because our laws are so broad that we enforce, we are not narrow experts in every industry where our laws might apply. And so often we have to look to industry and say, well, what is the standard reasonable basis to make a claim that something is land or blue turquoise? Is it certification or is it provenance? If there's a dispute within that industry, as a government agency that in enforcing the law would have the burden of proving that there was a violation of that law, it would put us in a difficult position to say, well, you actually need provenance to make this claim.
That's for us in criminal investigations, so if you do have provenance, it may help you. I'm not saying it's going to help you, but it also matters what your skill set is too. So if you were to purchase this, or you have someone purchase it for you, and you do have like receipts indicating this is what they sold you. However, you have knowledge that what you purchased after the fact was not what it was, and you sell it. Obviously, that's not going to protect you. But I mean, it's a combination of both. I mean, yes, it does help, and as everyone's saying, get it in writing. And particularly with the Indian Arts and Craft Act, if someone's selling us something that they believe is Native American made, and they have documentation, proof that who they're buying it from is represented to them as that way, it does obviously help protect you against criminal prosecution.
So, in retail sales, that's one thing. I know you said that there's probably not a difference between retail and wholesale, but when an artist is going to be buying a piece of turquoise to then have set in jewelry and then sell, are they following the same concepts, get everything in writing so that they can pass it on, or are there other protocols that they should be following?
I would recommend the same as far as documenting it, at the very least for their purposes. I think at the point that they're selling the jewelry at a market or something, the consumer is interested in them, their work, and what they're doing, and don't necessarily need receipts for the pounds of turquoise that came from the mine 50 years ago. But they do want the guarantees there at least, and whatever they are guaranteeing, they should be able to back up.
So how, between all of the different agencies, how do you guys ensure that people selling turquoise in the U.S. are actually following the laws? Do you monitor sales, or do you rely on consumer reporting? How does the process of actually watching the industry work?
So I could say from the FTC's experience, we rely heavily on consumer reports. We are an agency of 1,200 employees that has a jurisdiction that basically covers the entire American economy, minus banks, railroads, and a few other agencies that are covered by other federal agencies. You know, there are also state attorneys general in any state. There may be other state and local agencies with regulatory authority, but we don't have the headcount to be affirmatively monitoring every industry all the time. And so for any given industry, we are relying on reports either from a consumer, sometimes from a current or former employee, sometimes from a competitor. And one thing to note when it comes to, we've all seen aggrieved former employees or unscrupulous competitors, we conduct our own investigations. We don't take anyone's word for it. And so in terms of the enforcement actions that we choose to take, we rely on information coming into us, and that can come through a variety of different channels.
Yeah, the Indian Arts and Crafts Board is also largely looks at complaints that are coming into us. We get about 400 complaints a year, and we have a staff in the central office of 4 people, not all of whom are even principally working on review of complaints.
How did they let you come? You have 100 reports to look into this year. Why are you here?
Well, fortunately, a lot of complaints come in are not actually a violation of the Arts and Crafts Act. And fall into other things. But yeah, we're very busy. We don't necessarily have the time with our staffing level right now to proactively look. But sometimes there will be a sort of domino effect where looking at one complaint, you realize that there's a tip of an iceberg, and then you do dig more. So it is not just complaints. We also got together a few years ago. We've done this a couple times while I've been at the board with some of the state attorneys general's offices and with the Federal Trade Commission to pick like a 2 or 3 day period where we all look at the internet using different search terms and different search engines and see what's going on, and then generate letters to the businesses that we identify as selling art and craft work as American Indian or Alaska Native. And then we have records on who we've contacted about that as part of an education effort. So then, and a lot of what we do too is outreach. That not every complaint that comes into the Indian Arts and Crafts Board is going to get referred to Fish and Wildlife Service. Sometimes if it's somebody on Etsy or somebody at a flea market, the Indian Arts and Crafts Board will contact them, inform them about the act. They will make substantial changes to what they're doing, and we will then all move on. But we're at least on notice. We have records of putting them on notice if it comes up in the future, but we would consider that to be resolved. That the ideal condition is taking somebody from a state in which they're violating the Indian Arts and Crafts Act to a state where they're not violating the Indian Arts and Crafts Act, whether that's through education or whether that's through enforcement.
The one thing I think it's important to touch on is, so I'm looking over here at the laptop screen, the topic being laws, liabilities, and protections. The prospect of criminal liability, the prospect of liability to the Federal Trade Commission, it's like one very narrow corner of the overall theme of liability, right? There is contract law and there's private tort law that are, that I think should be, foremost in anyone's mind who's participating in this industry and thinking about this from the prospect of risk management, right? Because part of the risk is, what's my risk of the FTC breathing down my neck, or the Indian Arts and Crafts Board, or the Fish and Wildlife Service. That is a very small corner of risk. There's a much broader corner of risk, which is, what's my prospective liability to a consumer when I represent something to be true that I don't have documentation for? What's the reputational harm that can come from that? How do I maintain my good name? That extends even beyond legal liability as brand management, right? Is just sort of generally understanding, how do you build a good name, and how do you avoid the risks to that? Yes, there is a risk of violating any federal law, but there are also risks that come from making a misrepresentation to a discrete consumer, or violating a specific contract term, or warranting something in the paperwork in connection with the sale that not to be true, or that you don't have adequate support for.
So
Could I hop in there real quick?
can I add a question to that?
Of course.
And then it might help. You might speak to that too. So when we start getting into legal liabilities, I know a big ambiguous word is fraud, that could mean a bunch of different things. Is there a certain level that misrepresentation actually gets to fraud? Is it a dollar point? Is it how aggressive the misrepresentation is that would actually escalate from the small claims court to actual prosecution? And if you want to add to that, and
I can add from the fish side. So basically, when we look at violations of the Indian Arts and Crafts Act, anything over $1,000 is going to be a felony. Anything below is going to be a misdemeanor. And when we look at
at these individuals too, we also look at the fact is this a one-time event? Is this a misrepresentation that is just their lack of knowledge, or are they intentionally doing this over and over and over again? I mean, we take that into considerations, and at times we'll correspond with the Indian Arts and Craft Board, have them give them what we call a know the law letter, because maybe they just don't know. We have individuals that claim to be Native Americans that have heritage associated with it, but the way the Indian Arts and Craft Act is written, you have to be a enrolled member in a federal or state tribe, or be an Indian artisan, which is recognized by a federal or state tribe, and you have to have lineal ancestry to be the Indian artisan. So, I mean, all those factors take into effect for us, but as I said, we focus primarily on criminal. We do not focus on any civil aspects from the fish side.
Yeah, and then I guess small claims court had been brought up just a moment ago. Yeah, consumers have a variety of not federal remedies at their disposal, just person to person against a business that they feel has done them wrong. Going to their credit card company to contest the charges, bringing something up in small claim court, again, just vigorously pursuing reputational damage. Additionally, the Indian Arts and Crafts Act has a civil provision which allows an individual Indian artist, an Indian tribe, or an Indian Arts and Crafts organization to bring a civil suit in federal court against somebody for misrepresentation as well. And there's also a provision that lets the Attorney General of the United States, or basically Department of Justice, pursue a civil case on behalf of any of those as well. There have been some civil cases largely out of Chicago, so it's not entirely a thing that does not happen. So that is something you also need to be aware of, that it's not just us. There are a large number of people who, if they can show that they have a cause of action, can take an action.
One thing to answer the question that I want to make sure that, in case anyone is wondering about the distinction between fraud and deception. Fraud is essentially deception plus knowledge. But it may not, so when the FTC pursues violations of the FTC Act, we don't need to prove fraud. We don't need to prove that element of knowledge. It may be a consideration to the point Sean was making about how aggressively to approach something, what remedy we might be seeking, whether to pursue an action at all. Does this appear to be someone who made an honest mistake and might benefit from a conversation, a know the law letter, things of that nature? Or does this person seem to know exactly what they're doing and is intent on ripping off consumers? That's gonna, that's part of any sound decision making when you're dealing with discrete resources of an organization, is where are we gonna put our hours of enforcement effort. It may not matter for private litigation of state laws, which tend to be very similar to the FTC Act in that they speak to deceptive or unfair practices, not necessarily to fraud. So if there's, say, private small claims litigation, that knowledge element of fraud may not be a prerequisite. Now I'm speaking kind of in my general knowledge as a lawyer, certainly not as specifically through the lens of the FTC Act. But knowing that you're making a misrepresentation and going ahead with it anyway may increase your liability for things like damages, particularly punitive liability.
All right, let's talk about marketing. So with marketing, we all know that there's truth in advertising laws, but how do they work? If a company markets themselves, is that different than hiring a marketing company? Can I say essentially whatever I want about my own business, but if I hire somebody that's their profession, are there more restrictions on how they can market me?
From the FTC Act, perspective, there's no distinction. It's it's not less or more of a violation. Let me put it this way. So the way deception works, which again, the FTC Act applies to deceptive practices, is there a material misrepresentation that a consumer who's acting reasonably under the circumstances, so not the most sophisticated consumer and not the least sophisticated consumer, but a consumer acting reasonably under the circumstances, would misunderstand, and would it be material to their decision making? So is it something that's likely to affect their decision making? So you'll notice that in nowhere of those elements that is spelled out of what constitutes deception does it focus on, did you hire an outside marketing agency or not? Now, I don't think we have anyone in the audience here who is an outside marketer or as their particular profession. Am I wrong about that? Okay, so this won't be relevant to you, but we have occasionally in the past gone after outside marketing agencies. But one critical question there is, do they know that what they're saying is a misrepresentation, right? Because their job is marketing, their job is not Turquoise or sneaker sales or any, of the other various things we could get involved in. But for purposes of the merchant, the seller's liability, it doesn't matter whether you are making the misrepresentation yourself or whether someone is making it on your own behalf. From a government agency, again, with limited resources perspective, we might look differently about what action to take if this appears to be a rogue marketer who just needed to be reined in than someone who is following marching orders from the seller to make a representation that is false.
So with marketing, there's a lot of different gym shows out there. We have one upstairs if anybody didn't already know that. So if we were to use the Tucson Gym Show as an example, it's one of the largest gym shows in the world. Dealers from all over the globe come in. There is a lot of marketing for the Tucson Gym Show. There's the individual companies at an individual show. There are there's the show promoters. Then the city of Tucson does marketing. The state does marketing. All of you started off today with a disclaimer about that you are speaking on your own behalf, or that these don't reflect different things from different people. When we market that we're going to have a lot of dealers at our show, or come to Albuquerque to go shopping in Old Town, there's a lot of Turquoise in Old Town. Do marketers who do that need to put a disclaimer that not everything that's being sold is what you think it is? Is that something that marketers need to put a disclaimer about?
I'm not totally sure I understand the precise parameters of the question, but let me see if I can be helpful here. If you are, if it's a tourism board, the city, what have you, who's making is out there advertising for general tourism purposes, I don't know how anything that was false there or misleading there. I mean, I would hope that they're not making anything that's specific enough to be false across the board, but I don't know how that would tie to the individual seller. If you operating your own business make a representation about what is in your store, I think you'd want to make sure that that's accurate. I don't think you, by making a representation about what you are selling at the Tucson fair or here in Albuquerque, are vouching for the veracity of every seller that also happens to be selling in that same place. You're not ensuring that someone who buys from anyone in Tucson or in Albuquerque is going to walk away with the genuine article, right? That's not the scope of liability. I'm not sure if that was helpful in answering that. Yeah. It's more about what are you saying about what are you selling, and you're not, there's not a broader umbrella there.
I'm gonna punt on a lot of that and just say, we really need to have a specific example where
Yeah.
we're looking at it, digging it in. When you would get us cornered on stuff, we will often say, we would have to look at that on a case-by-case basis, and that's gonna be my reflexive response here. I would say the Indian Arts and Crafts Act civil provisions that I mentioned earlier were amended in 2000 to add language that says market directly or indirectly. But that is something that is in the civil provisions, so that would be pursued by an Indian artist, an Indian tribe, an Indian arts and crafts organization, or potentially the Attorney General, but could potentially be brought as a civil suit by any of those, and that just hasn't been tested, so I couldn't tell you. I can't point you to a precedent, and people are always gonna try to push the envelope, so.
So one of the things that everybody says is make sure you go to a reputable dealer. That is one of the most overused cliches in our industry. So how exactly do you find a reputable dealer?
From an Indian arts and crafts standpoint, go directly to the artist, I would say.
I mean, if you're looking for Native American art, I go directly to the artist, and obviously that's, when I say that's not a guarantee, I don't have a situation I can, apply to this, but I said go directly to the person making the jewelry. You're gonna be better off than going to a dealer that's selling it, not that the dealer, but again, there are certain dealers that are known as being reputable. Doesn't mean mistakes don't happen, but yeah, in general, my recommendation is that this is just personal. Go to the person that created or the person that mining it, directly to a mining company. If you're talking about purchasing turquoise or something of the sort, I go directly to the source. That's my perspective.
We are absolutely guilty of using that almost verbatim in our consumer tips. I would say, in this age, at the very least, use your iPhone to Google, not necessarily endorsing particular products or services, but you use your smartphone and the search engine of your choice, and just look up, say, Better Business Bureau, other consumer things, just Google the name of the business and fraud, and sometimes you get surprising results. Now that's, one way to do that. The other is, well-established industry groups that have member lists, that have particular codes that they say, at least formally say that they're following, at least gives you some additional redress.
Yeah, researching is key. I mean, before I purchase anything, I research it.
Yeah.
Price point might be an indicator too, when you're buying things. I mean, if it's too good to be true, it probably is.
Yeah.
It's the case.
And
And that's what we get all the time. I mean, they'll buy a squash blossom necklace for $200 and they think it's real. It's possible it's made by Native American, but probably very unlikely.
So at the museum, we're asked all the time for recommendations of where to go shopping. So now that I know what I'm looking at and I don't want to get ripped off, where should I go shopping? Where's a good place? And we always hesitate to give a recommendation because that could also be viewed as an endorsement, not just a recommendation. Is there a difference between a professional in the industry recommending a store or a dealer as opposed to, say, your neighbor telling you their favorite store or dealer?
IACB, they have a website
Yeah.
where you can go directly to individuals they've checked and said this is applying to the Indian Arts and Craft Act, where they know these people are enrolled members.
Right, we do have a source directory online of American Indian and Alaska Native owned and operated arts and crafts enterprises. Some of those sell jewelry, some of those sell turquoise jewelry, a lot of them do not. It's a national registry, and it covers a wide variety of art and craft work. But we have, at least at the Indian Arts and Crafts Board, and verified that the person that is running that business is an enrolled member of a federally recognized tribe.
So if I'm gonna give a recommendation, do I have to do homework like that too?
I personally would never give a recommendation without doing a lot of homework. I mean,
Do homework, but I'd still do a disclaimer, I mean, there
Yeah.
still could be fraud. It's possible that a Native American, and as I said, I don't have a situation, is selling stuff that they imported. I mean, ultimately, in the end, you just have to do your research and know who you're buying from, so ultimately, yes, I'm not gonna give, yes, buy from them. I would always disclaimer, you never know.
I would add two things to these excellent points. One is, not all recommendations are the same, right? Like, are you recommending, has the person specifically asked you, what I really want is a piece of Navajo jewelry? Or are they looking for something that's more in the style of something? And so what is being asked? What are you recommending? Like, you don't just say flatly, I recommend this place, full stop, or I've had good experiences there. You might be telling them something about the nature of what they can expect there in a way that you'd want to make sure you have verifiable experience in that way. The second piece, and this is more to, my first comment was more about common sense, consumer guidance, things of that nature. This is a little bit more about the FTC's jurisdiction. If you're being paid for that recommendation, you need to tell someone. If you're getting any sort of business benefit from that recommendation, you need to tell the person that that's influencing your recommendation. We do have endorsement guides out there, they're called, that are specifically to get to the point that consumers, whether it be someone on social media or, someone at the Turquoise Museum, that they're not getting something that they believe to be an earnest recommendation when in fact it's a paid endorsement.
All right, and then, Ken, I have heard some changes are being proposed to the Indian Arts and Crafts Act. Can you explain what those are and what their impact will be?
Okay. I can talk a little bit about that. So at this point, earlier this year, the Senate Committee on Indian Affairs released a draft set of language for a potential amendment to the Indian Arts and Crafts Act itself. So this would be the federal law. They had a comment period that ended also in the spring. That's sort of hanging out there. At some point, there's probably going to be some sort of further action on that. I would recommend people read that. Even though the official comment period has ended, I'm certain that everybody's legislators would be very happy to hear from them if they have strong opinions on that language. And that would change some of the definitions for who an Indian is. It would change some of the definitions for what a product is. Just some general changes, and it would do some enforcement changes. The other thing that is out there, which is still in an open comment period until September 1st, is a proposed set of changes to the regulations that is not the law itself, but the standard, the rules under which the federal government will be enforcing and interpreting the law, which are being proposed through the department, which would potentially broaden what an Indian product is for purposes of the act, to include not just the current arts and crafts, but would include industrial products, fashion, film, literature, television, music, probably some other stuff that I'm forgetting. It would also change who can represent something as an Indian product. Right now, under our regs, it requires that the work be done with 100% Indian labor for it to be considered an Indian product, and there are some potential changes to that in it as well. I can't really speak too much to the details on it. I do recommend that everybody who is in an industry that will be touched by it familiarize themselves with the regulations and make comments on it to the appropriate people, because it is going to affect just about everybody in the industry, some positively, some negatively.
So one of the questions in the video was, how do I protect my collection in the long run for my kids? So we talked about getting the paperwork that's going to follow the piece. But if I buy a piece and then get it appraised, or have a piece that has documentation to it, and 20 years down the road, 30 years down the road, we find out that the dealer who sold it misrepresented it in the documentation. Is there a statute of limitations on that documentation for if it escalated to the fraud conversation, or is it until everybody dies, the paperwork is still valid?
5 years for us on the phone.
Sorry.
Felony or misdemeanor, it's 5 years. There's a statute of limitations for misrepresentation.
But if, say, you bought the piece in 1992, when the law was already in effect, or say 1998, after the regs had gone into place for the current thing, there would be the 5-year statute of limitations on that purchase. But then if you inherit that piece and you know that there's that problem,
that's a
and
different
then
story.
you go to sell it, then you're starting the clock over again, and that's a whole new game.
And the 5 years applies to misdemeanors as well, so.
And then when doing identifications and appraisals, everybody in the room should be able to be aware and know that if you get on the internet, everybody and their entire family will give you an opinion on what you have. And that may or may not be tactful, kind, or considerate. So are paid for opinions the same validity as free opinions, and do they carry the same protections and liabilities between if it's paid for or if it's free?
I'll go back to what I said a minute ago about our endorsement guides, that if someone's providing an opinion that you paid for, and you're using that in connection with your marketing efforts, you should be disclosing that it's a paid for opinion, and not using, the prospect of someone else's expertise to bolster the validity of your opinion. It does not need to be an onerous disclosure, but saying that as an ad or paid for endorser is a good thing.
From an Indian arts and crafts standpoint, I go directly to the artist, obviously, and get their opinion on it. If I was to have anything looked at or appraised, we've had individuals that were, I don't know if it was a self-claim that they were an expert, but they've looked at things that, and people looked up to them as, decent appraisers, or, identifying a particular artist's artwork that were incorrect. So yeah, from an Indian arts and crafts standpoint, I go directly to the artist, or at least to their relatives that are familiar with their work, over just going to a general appraiser. But that's just my personal opinion.
Right, and certainly, people who are not giving their professional opinion in a professional capacity, where it is a regulated thing. So the Arts and Crafts Act would apply to the offer or display for sale. So the fact that your cousin looks at something on eBay and says, I think that looks legit, that's not gonna come up. It's what the person who's selling it is saying, and then in the case of if there's something shady, where somebody's, if somebody's getting reimbursed for making that, for backing up that claim, then that would potentially be other issues. It's very seldom that there's a freestanding crime that is just that crime. That there's always other things that are going on.
So when you talk to an attorney, they always say this is not legal advice. When you talk to a doctor, this is not medical advice. And when you talk to a tax attorney, this is not tax advice. Do the people in the turquoise industry need to start having a disclaimer like that when giving an unsolicited or solicited free opinion?
I would not offer a free opinion. That's just me.
I can't offer legal advice.
Yeah.
See, I told you that's what they always say.
I wouldn't rely on, when I say rely on, you can document that it appeared this way based on this person's, and then give their credentials to what makes them knowledgeable on the subject matter, if it's free advice, or if it's paid, advice in reference to appraising an item.
If it's paid advice, do you have some sort of potential legal recourse as opposed to freedom of speech if it's unpaid advice? Does that make sense?
I think our issue is always going to be because it's a truth in marketing law. If there's no marketing, then it falls outside what we do.
Okay.
That if your grandma passes down a basket and tells you a story about that basket and no one's selling it, and you pass that down and it's in your living room and everybody's got all their stories terribly wrong, it's only a crime when that goes into the marketplace
So
with that.
If grandma passes down a basket and I have no idea what it is because grandma didn't label it correctly, and I hire a basket appraiser, is that the same thing as posting a picture of the basket online and getting everybody's opinion on it? That's the question.
Okay. Well, I can't speak to that level of it.
I can't either. I mean, when someone misrepresents, we look at their due diligence in order to properly do what they're doing.
Okay.
I mean, mistakes happen, don't get me wrong. We notify people when mistakes happen if we believe it to be that, but, yeah, are they doing their due diligence when they represent their items? And as I said, that's a very vague term too. But have they done what they can do to assure what they're selling and advertising as such is correct?
I buy stuff when I'm out at events as gifts for my wife. After 20-something years, we have lost some of the cards. I do feel only sympathy for my nieces and nephews when they sort through that stuff, ideally in many years, figuring out what's what, because even because I'm just buying it as a person to have it around, and I'm not necessarily buying it as a collector or with an eye to investment or for passing down a coherent collection. I would say if you want to do something with intention, do it with intention from the start. And certainly if you're looking at passing things down, try to document what you can remember, even if you're kind of vague on it now, to at least give you some grounding for people who are going through that later.
All right, I got one last question on identifications and evaluations, and it's going to start with a story. This is an occurrence that actually happens on a regular basis. The last time I heard of this happening was actually a week ago. But I'm going to use a 20-year-old story where most of the participants are dead, so that this is mostly hypothetical. So about 20 years ago, we ended up meeting an artist who had purchased a squash blossom necklace that was set with Lander Blue Turquoise. He purchased the necklace, popped out all of the stones, made his own squash blossom necklace, and sold it at Indian Market. Then the buyer who bought it, it was a $9,000 necklace 20 years ago. So we don't want to guess of how much it would be worth today. Bought it 20 years ago, $9,000. They were extremely proud of their necklace, and they showed it all around Indian Market. And two of the biggest names in the industry, as far as their reputation, two big names told the buyer that it was Chinese turquoise, not Lander Blue, which of course takes the value from here all the way down to there. And so the buyer went back to the artist and said, "You ripped me off and I want a refund." So the artist said, "Well, how about if we get it appraised? Would you accept an appraisal?" And that's where we came in. They brought it to the museum to do the appraisal, and that's how we met the artist. And not only was, yes, it was Lander Blue and easily identified as Lander Blue, but the original squash blossom that he purchased came out of my great uncle's manufacturing business. So we knew specifically who cut the stones, not just, yes, it's Lander Blue. So wrote the appraisal, and he gave it to his client, and his client said, "Okay, I now believe that yes, it was Lander Blue, and you didn't rip me off." but because of the whole situation with the other dealers that said it was Chinese, I still want a refund. So the artist had maxed out his credit cards to give them a cash refund on a purchase that he represented correctly. So the question would be, and again, almost all of the participants in this story are dead, so it's very hypothetical in that sense. The question would be, is the two dealers who said that, does that fall under something along the lines of freedom of speech and they're allowed to say whatever they want? Or because it ended up causing $9,000 worth of damages, does that fall into more of a tortious interference with contract kind of world, and they could actually be liable for interfering in a sale?
I'm not familiar with any FTC case that involved the disparagement by someone of another person's sales practice. It's not the type of deception, if it is indeed deceptive, it sounds like there are differences of opinion that we would get involved in. There's a whole body of law that this could implicate, right? Defamation, tortious interference with contract, other private rights of action. That's just not part of the laws and regulations we enforce. I'm not in the best position based on that set of facts to tell you, yes, this was defamation. No, in fact, it was tortious interference with contract. I do think it tends to sound more like a private dispute than it does like something the government would tend to get involved in. But I would also defer to Sean and to.
It's nothing we would get involved with. It appears to be a civil issue. If that's the route someone would choose to take, but yes, we would not get involved with it.
Yeah, I'm not an attorney again, and I would recommend in something like that people do consult with an attorney on that. Now, that definitely sounds like something that needs to get resolved in court or else between people.
All right, so we've covered a lot of things today. Can each of you tell everyone what you believe the big takeaway is?
Wow. Oh, I guess, the big takeaway would just be, from my perspective, to document things and when you're buying, and ideally when you're selling. And since a lot of people here are in the industry, just everybody be cool. Be honest, be cool, and we don't have to be answering any of these questions.
I just, again, kind of what Ken said, basically document, do your due diligence on your part if you're the seller. Do your homework, check it. Maybe I'm a little bit, I don't trust anybody, so I do my homework when I purchase things. It's just that way. I've been lied to enough times, and I do my homework just to make sure. It doesn't mean I'm always gonna be right, doesn't mean I'm gonna get it right, but especially if you're talking about a high dollar purchase, do your homework and look for qualified individuals to help you in that process.
Yeah, experts make mistakes. Look for the
Yeah,
people who are at least gonna deal with you in good faith.
I think those are the fundamentals. Those are the big takeaways. One smaller takeaway I would add is you're not alone on this stuff, right? Like, there's a whole internet out there. The FTC puts out guidance on how to sell jewelry. It also puts out guidance that I think is worth reading to consumers on how to buy jewelry. And so understanding both sides of the coin, no pun intended there, is important, because you're gonna understand, like, what might the FTC be concerned about that consumers understand. Also, what do they want me to get right? But we're not the only agency here, and for each agency you may be interacting with, be it state AGs, be it the Indian Arts and Crafts Board, be it Fish and Wildlife, you're gonna be able to find guidance out there about the laws they're enforcing that are free, they're available on the internet, and they're generally written in plain English. They're not written in lawyer speak, and they're gonna be valuable to consider as you kind of do a little bit of a diagnostic on your own business and how you're conducting it.
So the end of the video said, we know this isn't the last conversation that will take place. originally in the planning for this, we had 7 chairs behind the table. It was a bigger table. We had 7 chairs for Attorney General's office, state and federal legislators, law professors, and a lot of the questions that they couldn't really get into. That was why we had the other panelists coming, and for one reason or another, they all weren't able to actually make it. So in the next couple of years in the next couple of Turquoise Uniteds, there will be another conversation like this to get into a little bit more detail with other panelists that can get into other subjects, as well as maybe some more detailed, deeper questions on the realms that they specifically deal in. So that'll be something to look forward to. But if you have questions for them that we didn't cover, feel free to ask them after. And the next session in this room will be the Turquoise Basics class at 1 o'clock. If you're planning to enter any items in the competitions, the entry deadline is 11:30, and that's going to be up in Ballroom B. Other than that, enjoy the rest of Turquoise United.
Thank you.